Hello viewers, how are you all today? Moving forward with the topic of negligence, today we will discuss the topic of negligence from the professional landscape relating to medical, legal and banking fields. So according to Winfield, as we have discussed, negligence as a tort is the breach of legal duty to take care that results in damages undesired by the defendant to the plaintiff. Now, we have also discussed that there are three essential elements of negligence: that the defendant owed a duty of care to the plaintiff, the defendant breached that duty, and the plaintiff suffered as a consequence thereof. In layman terms, negligence is carelessness. The most frequently affected professions include bankers, manufacturers, repairers and builders, doctors, surgeons, advocates, attorneys, company directors, carriers, innkeepers, and hoteliers. These professionals' recklessness can be characterized as professional negligence. Professional negligence occurs when a professional performs their obligation below the minimum requirements. It is important to practice a career or an art that calls for a specific level of knowledge, talent, and reputation. A particularly complicated area of law is professional negligence, which happens when a professional does not perform his duties to the required standard. Before defending against a lawsuit that involves claims of professional negligence, legal assistance should always be sought. A contract is broken if the required standards are not met. Allegations of carelessness and contractual breach are very different from one another, especially in terms of available remedies. When discussing any claim with a lawyer, this needs to be taken into account. Damages for the plaintiff's losses caused by the defendant's negligence may be included in a claim for professional negligence. In order to better understand each expert's liability, this presentation will define the terms used by medical experts, attorneys, bankers to describe professional negligence. A breach of a healthcare provider's or medical professional's duty of care that causes patients harm, injury or death is referred to as medical negligence. In order to guarantee that the patients receive the proper care and are made whole for any harm caused by medical practitioners, medical malpractice regulations have been implemented in India. In India, cases of medical negligence usually result in civil claims for damages being filed before the relevant court. In some circumstances, if a healthcare worker's negligence led to a patient's death, criminal charges may also be brought against them. Indian law establishes legal obligations for healthcare professionals to provide care that meets that level and respects patients' rights to acceptable medical care. A patient may be entitled to financial compensation if they suffer harm as a result of medical professionals' carelessness. Tort law serves as the foundation of the Indian legal system that oversees medical malpractice. Indian courts have established the reasonable care standards as the standard that medical professionals must adhere to when providing patients with medical care. According to this idea, a medical professional must treat a patient fairly and with consideration. The practitioner may be sued for medical malpractice if this is not done. Medical staff must also adhere to the 2002 Indian Medical Council Professional Code, Etiquette and Ethics Regulations. In accordance with these laws, medical workers are obligated to get patients informed consent, keep accurate records of patient care, and uphold medical ethics. Now let's talk about the meaning of medical negligence. Medical malpractice, often known as medical negligence, is the legal term for when a healthcare provider fails to give treatment that satisfied the required standard of competence and knowledge. The patient may suffer harm or injury as a result of this error, which may be the result of the healthcare professional's omission or commission. It's important to keep in mind that not all poor medical treatment are the outcome due to only of negligence. Because medical therapy is not an exact science, it can be ineffective under a variety of conditions. To demonstrate medical negligence, it must be shown that the healthcare provider breached their duty of care by failing to provide treatment that complied with the required standards. Now let's discuss the different types of medical negligence. There are many different types of medical negligence that can occur in the healthcare industry. Let's discuss some of them. First one is misdiagnosis. If a healthcare provider fails to correctly diagnose a patient's medical condition, or if they receive an incorrect or delayed diagnosis, they may experience pain or harm. Second is surgical mistakes. These can include handling anesthetic improperly, performing surgery on the wrong part of the body, leaving surgical equipments inside the patient, and other errors of the similar sort. Next is medication mistakes. These can include administering the medication in the wrong manner, using the wrong prescription or dosage, or failing to consider potential drug interactions. Next can be failure to obtain informed consent. A patient's informed consent is required before performing a medical procedure. Otherwise, the patient would not have been aware of the dangers and could have suffered harm or injury. Next is failure to provide appropriate follow-up care. After a procedure or therapy, healthcare professionals have a duty to check on the patient's condition and provide appropriate follow-up care. If this is not done, there may be danger or harm to the patient. Other is birth injuries as well. Negligence during labor can result in serious difficulties for both mother as well as the child, such as brain damage, paralysis, and other severe wounds. Next is anesthetic mistakes. A medical professional could provide too much or too little anesthetic, forget to monitor the patient's vital signs throughout the procedure, or do any number of other things incorrectly. It is crucial to remember that every situation is different, and the particulars of medical negligence will define the most appropriate course of action. Now, what are the challenges faced by victims of medical negligence in India? In India, people who have suffered harm as a result of medical negligence may run into a number of roadblocks in their search for justice and monetary restitution. Some of the key challenges include lack of knowledge. Many people in India may not be aware of their legal options or their rights in case of medical malpractices. Next is expensive legal proceedings. In India, legal actions can be costly and victims may find it difficult to pay for legal counsel and court. Next is lengthy legal proceedings. In India, the legal proceedings in situation of medical negligence can be protracted, which can be emotionally and financially taxing for the victims. Next is limited access to medical records. It may be challenging for victims to secure these records, which are essential for demonstrating medical malpractice. Next is insufficient evidence. It can be difficult to prove medical malpractice, and victims may find it difficult to assemble enough proof to back up their claims. Next is lack of support. Victims of medical malpractice may feel alone and unsupported because there is frequently little emotional or social help available to them. Next is healthcare professionals may have substantial authority and influence, which can make it challenging for victims to take legal action against them. These barriers may make it difficult for Indian patients who have suffered injuries as a result of medical negligence to receive justice and financial compensation. Victims must get legal advice as soon as possible and work with skilled lawyers who can help them navigate the legal system and get over these challenges. Now let's talk about adjudication liability in medical negligence in India. Cases are handled in civil courts, consumer forums, and medical councils in India, where the legal system is frequently employed to determine who is responsible for medical malpractice. Depending on the kind and extent of the claimed negligence, as well as the particular court hearing the case, the method for determining guilty may change. Victims of medical malpractice may pursue a civil lawsuit in civil courts to recover damages brought on by the malpractice. It is the victim's responsibility to prove that the medical provider violated their duty of care and that the patient was harmed as a result of the same. Patients or their family members may lodge a complaint in a consumer forum against a doctor, nurse, or hospital requesting restitution for any loss or harm sustained as a result of medical malpractice. If the forum determines that the medical negligence has occurred after looking into the complaint, it may order the victim to be compensated. Medical councils in India are in charge of policing the behavior of medical professionals in addition to the civil courts and consumer forums. If a patient thinks a medical professional has violated their ethical commitments or standards of care, they can complain to medical councils. The council may take disciplinary action against the healthcare provider, including withdrawing their license to practice medicine if it determines that they acted irresponsibly. Now let's talk about the related provisions for medical negligence in India. The Indian Penal Code of 1860, the Consumer Protection Act of 2019, and several rulings by the Supreme Court and High Courts all govern matters of medical negligence in India. In India, the following clauses and defenses apply to situation of medical negligence. A medical worker who causes a patient's death through carelessness may be sentenced to up to 2 years in prison, a fine, or both. A medical worker who recklessly jeopardizes the life or safety of a patient may be sentenced to up to 6 months in jail, a fine, or both. A medical worker who negligently causes serious harm to a patient may be sentenced to up to 2 years in prison, a fine, or both. Now talking about the Consumer Protection Act of 2019, this law gives patients the ability to complain about doctors and seek financial compensation for malpractices. There are certain defenses with respect to the same. The first one is error in judgment. A medical professional may not be held responsible for negligence if they treat a patient and make an honest and reasonable error in judgment. Second is emergency situation. A medical professional may not be held liable for negligence if they acted in good faith to save a patient's life. And third is contributory negligence. The medical provider may not be held entirely responsible if the patient's own negligence contributed to their illness or death. Now let's see some of the Supreme Court landmark judgments with respect to the same. The Supreme Court of India has rendered a number of significant decisions in matters involving medical malpractice. Here are few of the noteworthy ones. First one is Bolam versus Hospital Management Committee, 1957. This case, the court established that Bolam test, which states that a medical professional is not guilty of negligence if they have acted in accordance with the practice that a responsible body of medical men skilled in that particular field has accepted as proper. The next case is Indian Medical Association versus VP Shanta, a case of 1996. This case created the idea of informed consent, which states that a patient must be fully aware of the risk associated with the medical operation before providing assent. The Supreme Court ruled that the failing to get a patient's informed permission can qualify as medical malpractice. The Supreme Court detailed the standard of care that medical professionals must follow in the case of Martin F. D'Souza versus Muhammad Ishfaq in the year 2009. The court ruled that a medical professional must possess the knowledge and abilities that are typical of a practitioner in their field of expertise. In 2008, a case of Samira Kohli versus Dr. Prabha Manchanda, vicarious responsibility in circumstances of medical malpractice was discussed. The Supreme Court ruled that even if a hospital was not directly at fault, it could nevertheless be held accountable for the actions of its workers. In the year 2009, in the case of Malay Kumar Ganguly versus Dr. Sukumar Mukherjee, the use of expert testimony in case of medical malpractice was discussed. The Supreme Court ruled that expert testimony can be used as evidence in a case of medical malpractice, but it shouldn't be the only factor considered when determining whether carelessness actually took place. The Supreme Court in another case of Kusum Sharma versus Batra Hospital and Medical Research Center in the year 2010 that a patient has the right to financial compensation for medical malpractice even if they did not sustain any bodily harm. The court ruled that a patient's mental suffering and anguish brought on by medical malpractice can also be compensated. These key rulings affect India's medical malpractice legislation and gave both patient and medical professionals some direction. In India, medical malpractice is a severe problem that can injure patients, cause fatalities, and devastate the families of those affected. The Indian Penal Code, the Consumer Protection Act, and other rulings by the Supreme Court and the High Court serves as the foundation for the nation's medical negligence statutes. The next is legal practitioners and negligence on their part. A lawyer will be responsible for the result of failing to follow or being unaware of the court's rules of practice. Additionally, he will be held accountable for the carelessness with which the case was prepared for trial and the improper management of a case that was typically directed at a member of his department's profession. A solicitor might be sued for damages on the grounds that he neglected to file and pursue an appeal because if he had done so without being negligent, his client might have received justice. If a client can show that the act, such as enabling a claim to be time-barred or being dismissed for failing to request a trial date within the required term led to the loss of the cause, the solicitor is accountable for the negligent act. The lawyer will be held accountable for his partner's or agent's carelessness actions as well. In Country Personal Employment Agency Limited versus Allen, it was determined that a lawyer had breached his duty of care to his client by failing to inform him of the implications of a peculiar clause in a lease while negotiating an underlease. However, a solicitor has no obligation to the beneficiary when he or she represents the testator in a subsequent transaction involving property that is subject to the will's protection. A counsel advising a partnership is only required to advise the partner handling the subject on behalf of the company unless extremely unusual circumstances require him to do otherwise. A lawyer often has no duty of care to the counterpart of his client, although in exceptional cases he might. If a legal action involves an assault on the judgment of a court with appropriate jurisdiction, a lawyer cannot be held accountable for carelessness in the administration of either criminal or civil proceedings. Therefore, a plaintiff who entered a guilty plea and was found guilty by a criminal court cannot sue his lawyers or damages alleging that they were being negligent in telling him to enter a guilty plea. Now let's talk about bankers and negligence on their part. The Banking Regulation Act of 1949 defines banking as the accepting of money from the public for the purpose of lending or depositing investments, repayable on demand or otherwise, and withdrawable by draft, check, order or otherwise. In conclusion, a banker is someone who accepts current and deposit accounts, pays and issues checks, collects crossed and uncrossed checks for his client, and manages current and deposit accounts. Bankers are not held to the same standards of carelessness as private individuals. Society is generally given precedence by public institutions. No one in particular is motivated to acquire it. Public institutions' affairs are overseen by hired staff, most of whom aren't just there for the money. Any agent who signs a promissory note, check or bill of exchange in his name without disclosing that he is doing so, or if he does not intend to later assume personal responsibility, will be held personally liable, with the exception of those who convinced him to sign under the impression that only the principal would be responsible. Customers of the bank keep their money in the banker's hand for their banking needs. They are skilled individuals and people deserving of trust. Their responsibility is to honor customers' checks for any amount that does not exceed credit balance and to respect the payment of customer checks. A commissioning error is negligence and makes the offender liable for damages, which may include harm to the customer's credit. If a banker is negligent, the bank will likewise be held responsible if any employee is negligent while acting in the course of employment. Additionally, they are accountable for paying counterfeit checks negligently. Due to the fraud committed by the customer's servant, the banker will be held responsible for any losses if bank drafts are issued without authorization in accordance with the customer's instructions and against legitimate customer checks. Additionally, even though there is no element of carelessness, the banker's liability is absolute if he delivers the goods or money that he received on behalf of the customer to the incorrect individual. So to conclude, when professionals are held accountable, the consumer client or patient benefits from the payment of their damages that were brought on by the expert's negligence. Even though they occasionally fall short, professionals will endeavor to work efficiently because there are regulations against professional negligence. In the case of CBI versus K. Narayan Rao, the Supreme Court has made it clear that in legal terms, experts with certain skills, such as doctors, architects, lawyers, and others, fall under the definition of negligence. The client is not expected to receive assurance from the attorney that he will always prevail in court. He can only promise to use his unique talents with fair competence. Therefore, experts can be found negligent in one of the two situations. Either they lacked the necessary skill they claimed to have, or they failed to act reasonably competently in the situation in which they did. I thank you very much for attending this lecture. I hope you learned something. Thank you.